So hello everyone. Good evening to our Indian participants and a very good morning to our UK participants. Thank you for joining in such an enlightening webinar today. We have some great three eminent speakers today. Mr. Richard Bamforth, who heads the arbitration group practice of CMS, which is one of the largest law firms in the world. Richard has more than 2 decades of experience in commercial arbitrations in various sectors, from telecommunication to infrastructure to media to entertainment. He also acts as arbitrators in many cases. So he's a well-renowned lawyer in the Circuit of England. Then, who is the General Counsel of UFO Moviez, one of the largest distribution network companies in the world. Zameer again has a experience of 2 decades of having as an in-house counsel, worked with companies like Raymond to Balaji to Reliance, has worked on M&A transactions to arbitrations to compliance related issues. Then we have Anita de Villiers, who's a Western Australian qualified lawyer, is a senior associate with CMS and works very closely with Richard. I mean, when the idea and the purpose of this webinar was how and why, what will happen post COVID-19. We all are debating as attorneys across the world, in every country, in every city, what's going to happen post COVID-19. Whether companies are going to invoke frustration or force majeure, or whether companies are will go into mediations or arbitrations. Organizations across the world have become now very cost centric. They will go on cost saving. So I personally believe that there will be a lot of commercial mediations which will happen. Maybe in high value transactions and high value litigations, there will be arbitrations or there will be court proceedings. But in smaller litigations, mediations might happen. Maybe a vendor contract, a supplier contract, a distribution contract. Clients won't like to spend money. They won't like to spend money on litigation now, either in arbitration or either in court. So Richard, I think, will take us through what's happening in UK right now. How is UK coping up with this global pandemic, and also what's going to happen next. Zameer will enlighten us with respect to force majeure, and also he comes from an in-house background, which is a very important position in an organization today. He heads a legal department. So his point of view, how he is coping up with this situation, how he intends to cope up, he will bring that to us. Secondly, very important for us, especially for Indian colleagues over here, let me enlighten you with the statute called Commercial Courts Act, which was enacted in the year 2015. And in the year 2018, there was an amendment in the act which says that mediation is now mandatory for commercial disputes. Wherever a very important interim order needs to be taken from the court, in that cases only you should approach the court. Where there is no urgency, go for mediation. I think Zameer would explain you everything in detail thereafter. And then we have Anita. Anita will actually enlighten us with the legacy which will leave behind post COVID-19 in UK, and also mediation. Very important. How UK and how organizations in UK are going to look at it. Are clients willing to go for mediation? Are they going for cost cutting, or are they going to the courts, or will they do arbitration? So it depends on a case-to-case basis. It's not mandatory that everyone will go for mediation or arbitration or court. So on a case-to-case basis, things will be decided by the client and the attorneys. Thank you so much once again for joining. That was the introduction of everyone. I hope that this session and this webinar is very, very informative to all of you. Richard, over to you. Thank you so much.
Nidhish, many thanks. Good morning or good afternoon to everyone, wherever you are. I'm Richard Bamforth, as Nidhish has said. My role today is to talk about two particular areas. Firstly, how dispute resolution systems from what we may call now the old world are coping with the C-19 pandemic. And secondly, I'll then go on to talk about what sort of claims and disputes we might expect to see, both what we've seen already during the current crisis, and also then what we may see when eventually, and who knows when eventually is, we emerge from the other side. So first of all, just by way of a brief apology to start, and one should never apologise at the start, but I'm going to anyway. I'm an English lawyer, so I'm going to approach these things from the point of view of an English lawyer practicing in London. So I'm coming at it from that perspective, but I hope nevertheless you find those observations helpful. So starting with the court system, the courts have had to adapt very quickly to the COVID-19 pandemic. As far as I'm aware, there are very few, if any, courts which are now operating physically anywhere in the world. I think all the physical court systems have closed down pretty much across the world and globally. Courts have reacted in many different ways to the pandemic. So some courts, for example, have pretty much closed completely and are not doing any business at all. And I think that's certainly the case, for example, in places like Mauritius. But other jurisdictions have moved quite quickly and quite efficiently to online and virtual court hearings, and they're dealing with court hearings, often trials, interim applications, by Skype or indeed, as we're doing here, by Zoom. So there's a lot of variation in terms of what the courts are doing around the world. If you're interested, there is a website which is remotecourts.org, which is a very useful guide to over 40 jurisdictions and what they're doing in relation to coping with the situation. So I'd commend that website to you, and I'm sure we can provide those details to you if you need to see them after we've finished. The position in India, as I know that Zameer is going to talk about this in a bit more detail, but I understand that there is a direction from the Supreme Court that hearings are going to be carried out, or should be carried out at all levels of court, by video and e-filing. So in India, you're already seeing the remote court situation and online filings working to try and keep things moving. In the UK, the judges are very much trying to maintain a business as usual approach to dealing with things during the current situation. But things have to be dealt with on a case-by-case basis. And so how matters are dealt with will depend very much on the length of the hearing, what sort of hearing it is. Is there a lot of witness evidence? Is there a feeling that the technology will cope with the volume of witness evidence? Witnesses may, for example, not have access to appropriate technology. So if a witness can't access the technology to enable him to give evidence, then that's obviously going to cause a problem. Equally, of course, what we may also be seeing is respondents or defendants doing their best to use COVID-19 and the pandemic as an excuse to prolong things. If you don't want a hearing, then it's obviously an easy excuse to pray and aid the fact that things are terribly difficult and you need a physical hearing and you can't have a remote hearing. And so often that's being used as an excuse or a reason not to progress things. But by and large, certainly in the UK, the courts are doing their best to try and move the situation forward. And the arguments around delay being caused by the pandemic are being dealt with, from that perspective. The starting point is that we need to try and get on with this as much as we can. There are clearly some challenges that this brings. So, for example, issues over service we are traditionally brought up in an environment where service of documents has to take place physically. But what do you do in a situation where the premises are closed or shut down or not manned? The systems have to be able to deal with that. So service by email is obviously a solution there, but then you need to make an application to court for permission to serve by email, and there needs to be proof about service of email. I've got a situation at the moment where we've been trying to serve some documents in offshore jurisdiction, and the documents are stuck in customs. So we had to apply back to the court to say, pandemic, documents stuck in customs, and then we got an order to serve by email. So the courts are being flexible, but they're equally just trying to cope with things as they come up on a case-by-case basis. We've also got the technology limitations to cope with. Issues over Wi-Fi reliability, bandwidth, etc. And frankly, the user's technological capability. We all had to get on this call 15 minutes early just to make sure we could all deal with the technology. So I think that's an example of where we're all having to deal with these things. You've got people like me who are not used to dealing with technology, looking at things in a very different way. So those are some of the challenges. But those are what I would call the practical challenges. I think some of the things that we're also having to deal with are the conceptual challenges, or the fundamental point that the system that we're used to in the UK and the system you're used to in India, for example, is that our system is based on an adversarial system. It's based on people sitting across a courtroom or standing in a courtroom, challenging each other, cross-examining each other. You have to face each other, and you're reading body language. You're reading the opponent. Now, there's a school of thought that no matter how good this is, you can't see what I'm thinking because I'm on a video. And if you're cross-examining me or trying to get information out of me as part of the process, it just isn't the same. And so can we really genuinely replicate the court environment? No, probably not. There are challenges as well around advocacy. Advocacy styles have to change when you're doing it in front of a screen. That's another example of the problems that people are having to face. And as well, is it good for one to spend as much time as we are now doing sitting in front of a screen? So accessing electronic documents, do you have to have different screens? We're used to physical bundles. Some of these things we are still getting used to. So the court system can't be perfect by any means, but it's doing its best, but there are definitely challenges. So that's the court system, a very brief overview. I mean, there's been a lot written about all this over the years, and certainly in recent months about the move to online courts. But that's where we are in the UK. We're doing pretty well, but it's not the same. Moving now to arbitration, we have similar types of issues in arbitration in terms of the difficulty in replicating traditional hearings. I've got a situation where a witness was stuck, frankly, in the jungle in a remote facility in Asia. The witness would have come to the physical hearing but couldn't do so. But it was a crucial witness in a particular case, so the remote hearing just wouldn't work. We also have concerns in arbitrations, I'm sure you all know, over due process. It's very important that everyone has the right to be heard and the right to present their case in the right way. Respondents traditionally rely on that in dragging their feet. And so it requires a robust tribunal to adopt different mechanisms to make sure that everyone gets a fair hearing, but equally so that the arbitration progresses. But one of the advantages of arbitration that we do see is that it has an inherent flexibility about it. It's not bound by specific court rules as national courts often are. So there's an inherent flexibility in that. It's also a more international process, so it's more used to dealing with cross-border cases. It's privately funded, which means that parties are more aware of the cost of flying people and trying to find different ways to do it. So, I mean, by way of example, I sat in an arbitration 4 or 5 years ago now, where we conducted the video cross-examination of witnesses by a link. Technology wasn't perfect, but even then there was an acceptance that was something that we needed to do in order to move things forward. So that flexibility has always been there in arbitration, and now it's tending to come into its own. There are also more flexible measures that one can adopt, such as reduced documentary disclosure, more written submissions. Tribunals are very much a master of their own procedure, and the parties are encouraged to adopt procedures that are suitable to particular cases. And frankly, that's now really where we are at in all forms of dispute resolution. The courts are catching up, but arbitration is very much ahead of the game in that front. Equally, the arbiter institutions, the people that organise the arbitrations, they're ahead of the game too. So the ICC has produced detailed guidelines about the conduct of online hearings. The Chartered Institute of Arbitrators has done the same thing. They've produced a guidance note, and they're not the only ones. Lots and lots of institutions are producing guidance notes, theories about how things should be done, technological protocols about the use of technology in arbitration generally. So arbitration, again, is taking things forward in a way that has always been the case, but it's now more accelerated. What we're also seeing, incidentally, in the arbitration world is arbitration centres, the places where physical arbitrations used to take place. Now saying, okay, we're not doing physical arbitrations, but what we're going to do is to move to a coordination of online arbitrations. So we have Maxwell Chambers in Singapore, or the new International Arbitration Centre in London, are now offering complete virtual hearing services. They're saying, we're open for business, we're ready to receive your arbitrations, even though you're not going to be here. Only yesterday, you may have seen in the legal press that there's been set up what's called the International Arbitration Centre Alliance, which is arbitration chambers, Maxwell Chambers, and the International Arbitration Centre coming together to say, we can do this on a global basis. We can offer global arbitration facilities on an online basis, so you don't need to be physical. And that's really important, and that will continue. So again, in arbitration, there's no shortage of willingness to really maintain business as usual as much as possible, or guidelines to enable the same. I'll touch briefly on mediation. I'm conscious that others are going to address mediation as well. First of all, mediation is perhaps more than any other form of dispute resolution process, one which involves reading body language, which involves physical movement, which involves a holistic approach to dispute resolution. And my own view is that that's very difficult to replicate on an online basis. I am aware of situations where people have attempted online mediation through Zoom situations or Zoom arrangements, whereby they have separate rooms and online and jumping around. There is the technology available to do it. I've seen that technology in operation. But in my view, during the real shutdown, I think that's quite a challenge, I think, for mediation. And certainly anecdotally, I'm hearing that a lot of mediations are just simply being put off, which is a shame, because I think people aren't necessarily adapting the technology in the right way. So that's a brief overview of the processes, how they're working in the lockdown environment in a C19 situation. I know that both Zameer and Anita are going to cover the future, but that's a snapshot of where we are now. I also will just cover in the next 5 minutes or so, very, very briefly, what sort of disputes we're seeing at the moment, and also where we think the world is going to take us in the disputes environment. First of all, the words that are being bandied around most obviously at the moment and used most frequently, and Nidhish opened up by referring to them, force majeure and frustration. That, believe me, is a whole topic of itself. What is force majeure? What is frustration? But there's a lot of talk about it. So I thought it was worth just addressing very briefly a couple of very basic concepts around force majeure and frustration. First of all, force majeure is by no means in the common law system the cure to all ills. Force majeure only applies, it's very important to remember this, if it is written into your contract. So without a force majeure provision in your contract, force majeure is not relevant to your dispute. So you can only take it so far. So first step, look in your contract, is there a force majeure provision? Second step, even if there is, as certainly it's a matter of English law, they're construed very narrowly. So look at the precise terms of that force majeure contract. So while it's a phrase that's often used, it's actually in reality sometimes quite limited. We see it most often, for example, in construction contracts. Construction contracts, by and large, will have a force majeure provision in them. But other things, such as leases, for example, may very well not have such a provision. So first step, be very aware of that situation. If you haven't got a force majeure contract, or in parallel with that, look at the doctrine of frustration. Doctrine of frustration is, in theory, a broader doctrine because it doesn't need to be written into the contract. but equally it is also construed quite narrowly in the situation where the performance of the contract is not possible because of the intervening of what we would call a frustrating event. So the subject matter of the contract ceases to exist because it becomes impossible to perform. Now, I'm slightly aware of time, but I'm going to just do something which I wouldn't normally do and just cite a particular case, because I like a case with good facts. So the illustration of frustration comes from a case involving the coronation of King Edward VII in London in the early 20th century. Someone rented an apartment to observe the coronation procession. The coronation procession was then cancelled. And so the individual tried to say that the contract for the rent of the apartment was frustrated because the entire subject matter of the contract, namely the viewing of the procession, no longer existed. And the court held that was a valid frustrating event. So while we can apply those basic concepts to more modern types of situations, it's a good illustration of how frustration may apply. But again, it's very much on a case-by-case basis. And in terms of what we've been seeing, we've been giving a lot of advice on force majeure and frustration, particularly in the early days of the pandemic, when people stopped performing contracts. Were they entitled to stop performing under contracts? How would it all work? But that was quite early on. What we're now starting to see as things what I may call settling down is there are more cases about the consequences of non-performance of a contractual obligation. So, for example, I'm involved in a situation where there's a real estate deal to purchase assets, but completion didn't take place. So was that because COVID-19 intervened and the party didn't want to complete, or because were the conditions precedent really not met? Again, that will be the subject of debate, but that's a good illustration of the sort of case. Or, for example, a television production company that's contracted to provide programming for worldwide licensing. It's making a program going to license it around the world, but all of a sudden it can't make the program because there's no filming going on. So how does that affect its contracts to on license going forward? We're seeing real examples like that now starting to come to the fore, and it's going to be more and more of that, I think, in the short term. We're seeing supply chain challenges. So the inability of a supplier to deliver into the top of the chain has a knock-on effect all the way down, and that's going to require contractual analysis. It's going to require some of the thinking around force majeure and frustration we've talked about. So these are real challenges. The practical challenge that people are going to have is how they're going to pay for some of these disputes, because businesses don't have cash to spare on their disputes, but sometimes they're going to have to fund the disputes, because without pursuing a third party, that's going to result in possibly the failure of the business. And I know that Zameer is going to talk about things from the other side of the fence, from the in-house perspective, but from a private practice perspective, those are the sorts of queries that we're starting to see now. I think it's also perhaps worth just touching on the concept of litigation funding. Now, litigation funding is something that we're very familiar with in the UK, where third-party funders effectively put up the capital to enable a party to bring a claim. I think now is the time for third-party funders. I think we're going to see third-party funding become more relevant in the UK as businesses say, well, I can't afford the capital to pursue this dispute. I've got to pursue it. So I'm prepared to take some third-party investment in that case. I think we're going to see more and more of that. We're going to see finance disputes. We're going to see insolvency disputes. We're going to see real estate disputes. Effectively, those sorts of disputes where people can't pay their rent, and what are the consequences of that? There's a lot of that we're going to see, and we've really just started to embark upon that journey. Just before I finish, and I'm conscious I am running out of time, to Nidhish, if I could see him, would be tapping his wrist now at this point, so I'm going to stop very shortly. But one of the interesting legal issues that I think we are going to see, and maybe we can talk about this offline separately, is questions of damages, calculation of damages. Damages in a common law environment are often driven by concepts of foreseeability. So COVID-19, how foreseeable was that? And what about issues such as remoteness and mitigation of loss, steps that parties have taken in an attempt to mitigate loss during the COVID-19 pandemic? From a legal perspective, really interesting issues. From the perspective of the clients don't want to hear about really interesting legal issues. They want to hear about solutions. But the practical question of what damages am I entitled to is going to be really, really relevant to a lot of your businesses and a lot of your clients' businesses. So those are my thoughts from a UK private practice perspective. I hope they've been useful. I'm now going to hand over to Zameer, and I hope he doesn't disagree too much with what I've said, and obviously happy to take some questions afterwards. So thank you everyone for listening.
Yeah, so I don't disagree with you at all, because we are in this we are in the same boat today. And is my screen visible, Nidhish? Sorry, your voice.
Absolutely, absolutely, it's there.
Okay, am I audible too?
Yeah.
Okay. All right. Good afternoon, everyone, and thank you very much, Nidhish, for this opportunity of calling me for this particular session of dispute resolution post COVID-19. Uh, when I speak from a corporate perspective, and I have a presentation because I feel content is important, because I'm in entertainment business, and if you don't have a good content, your film doesn't work. So I am a strong believer of that. Uh, Today, from a corporate perspective, I'm going to look at some areas where, after having served around more than 1,000 force majeure notices, whether COVID-19 will increase legal disputes, uh, whether companies can afford or prioritize cost and expenses of litigation during this crisis, whether commercial mediation or pre-litigation mediation will be more advisable before initiating any arbitration or litigation in the courts of law, uh, provisions of commercial courts and provisions for mediation which has been done there, and as we say, our second love. So for our first love is about the sections of the law, and the second love is about case laws and judgments. So some judgments which are applicable in today's date, and a transactional and litigation graph, which can be helpful for everyone, including the law firms, which normally is seen during the crisis. Okay. Now, whether COVID-19 will increase legal disputes. So here is the 2020 market capitalization. Of course, this is United States, but industry-wise, it will be applicable in all parts of the world. The 2020 market capitalization has declined for these particular sectors. So accordingly, when there is a downfall in negative, normally the expectation is that there will be restructuring, there will be bankruptcies, and therefore this chart can be useful in assessing what areas or industry will be more inclined towards the litigation part of it. Normally the legal dispute now will arrive uh, because of the overwhelming nature of the COVID-19, which would result in slew of disputes, even litigations which could spread across sectors like cross-border trade, real estate, your engineering contracts, your joint venture contracts, uh, act of God for non-performance, M&A deals, etc. Very few contracts in India include pandemic as a force majeure event, as it was never anticipated. We have the old law, which has a definition of epidemic, and therefore the word epidemic has been used during the notifications also. Uh, it all depends on terms between the parties. Inevitably, all contracts will be put to litmus test, while some of the cases may get amicably resolved. In others, litigation is inevitable. Sustainability of claim would also depend on the language which we have written for the force majeure. In the absence of a force majeure clause, one would have a backdrop of section 56 of the Contract Act, which then renders your contract void. So whether you want as a temporary suspension, and section 56 of the contract, which speaks about a contract which can be void. Companies may face allegations that it has used COVID-19 situation to wriggle out of their payment performance. Businesses will then have to demonstrate that they were indeed hit by the disruption caused by the pandemic outbreak, and not by financial difficulty and general slowdown. So we are expecting an increase in legal dispute. However, the companies will really have to think whether they can afford or prioritize cost and expense of litigation during this crisis. Uh, the corporate players would prefer to avoid going into litigation at all cost. However, that certainly does not mean that litigation would come to a grinding halt. The mechanism of litigation, the mechanism of dispute resolution would have to change to an extent, which I'll talk about in my further slides. But obviously, there would be discussion in terms of cost for non-effective hearings. Obviously, five-star arbitration and business class has taken a backseat for the moment. But I feel institutional ADR mechanism can provide an alternate similar to WIPO dispute resolution model, which has been there and which Richard also just now spoke about, international commercial arbitration institutions coming together for providing those kind of services. Uh, there is an example which is there for Hong Kong. Even China has recommended international arbitration uh, for using internet arbitration as sort of. Uh, but in the face of the issues which are going on, the example which I could cite today is about Department of Justice of Hong Kong, where they have launched an online dispute resolution scheme for which dispute involving micro, small, and medium-sized enterprises can be resolved. Under this scheme, a low-cost three-tiered method is proposed, which is to be followed, which is first about negotiation, second is mediation, and if both of these fail, then arbitration. Uh, in India, situation is continuously improving. In addition to video conferencing hearings and e-filing facilities, most of which are gradually being implemented in more courts apart from high courts and Supreme Courts. Uh, I was just chatting, I was just on a webinar talking on e-courts with the Joint Secretary of Ministry of Law and Justice. Apparently in 2017, I had written a big article on e-court, but that was from a perspective of public and government convenience and courts, without knowing that it would become so important in today's date for execution. Government is looking into those things. But apart that, we may take the following measures. We can develop a framework policy to enable courts, court annexed online dispute resolution ODR through mediation, conciliation, and arbitration specifically for COVID-19 related disputes. We can adopt and infuse technological solutions in designated courts in each district to facilitate court annexed ODR through ADR mechanism. While we talk about whether the disputes will rise, there is a cost efficiency which would be required in taking a cost benefit look for a litigation. Commercial courts did make a provision for it, and those amendments were also approved in 2018. Commercial Courts Act was established, and commercial courts were established by virtue of the Act of 2015. The Act was also amended, which came into effect on 3rd May 2018. Now, if you look to the provisions of the amendment of this Act, it introduced a Chapter 3A and Section 12A, which said a suit which does not contemplate any urgent interim relief under this Act shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation. I think that was one of the great steps which the government has taken to introduce this, comparing to the ratio and the numbers of litigations which are pending in the court. Mediation to be completed within 3 months from the date of application by the plaintiff. The period of mediation may be extended for the further period of 2 months with the consent of the parties. The settlement arrived at under this section has to be in writing and shall have the same effect of an arbitral award. On 3rd July 2018, the commercial court were notified. Pre-institution mediation and settlement rules were also notified by the central government pursuant to Section 12A of the Act. Therefore, I feel that provisions of Commercial Courts Act alternative mechanism which is available to us by virtue of negotiations and mediations will be more exercised, because there might be a debatable question on whether the performance was really affected by force majeure, or force majeure is just an excuse for avoiding the performance of the contract. Coming to the segment of case laws, if you see commercial courts also, there was a judgment in Sony Music versus Moby Media International, Bombay High Court on 27th February 2019, where, because of the amendments which were brought because of the Commercial Courts Act, the defendant's written statement was not taken on record after expiry of the 120 days from the date of service of the writ of summons. In Red Bull versus PepsiCo, Delhi High Court on 28 August 2019, the summons were deemed to be served after the parties by consent agreed to terminate the mediation process referred to in Section 12A of the Commercial Courts Act, and the delay in filing the written statement due to mediation process was also condoned after imposing the cost. So there are judgments which are focusing on that. Very famously, today's discussion turns around force majeure judgment of the Supreme Court, which came in 2017. Nobody thought at that point that this judgment will become so important from a point of pandemic and epidemic also. There was a dispute which was happening between reputed power producers on one hand, and there was Central Regulatory Authority on the other hand, which was now adjudicated in favor of the central authority with some instructions and guidelines. However, the Supreme Court held against the power producers on the force majeure clause as well as on the change of law arguments. The force majeure clause was construed narrowly. On the construction of the force majeure clause in the power purchase agreement, hindrance could mean an event wholly or partly preventing performance. So what happened in this case was basically the Supreme Court said that hindrance cannot be a ground for an excuse to perform the contract unless the performance itself has been affected by virtue of that. Change of law argument was put because there was some changes which were introduced internally from the government point of view. But the Supreme Court also remarked that a change of law in Indonesia law and thereby increasing the price of the coal would not be applicable. Change of law argument would mean change of law which has happened in India. So a narrow construction of the force majeure clause which was done by the Supreme Court in this case, and which could be a precedent for interpretations in the cases which would arrive out of this particular crisis which we are looking right now. Overall, recent judgments which have come in COVID-19, just to give a reflection on what directions the court is going or would go in future. There was a standard retail case, a steel case, what we say in Bombay High Court recently, where the court refused force majeure exemption to steel importers who had sought to restrain encashment of their letters of credit, holding that steel has not been declared essential services during the lockdown. In the case of Delhi High Court, in the case of Halliburton, the court held that lockdown prima facie, essential services, it has been declared as an essential services during the lockdown. In the case of Delhi High Court, when we are talking about Halliburton, the court held that lockdown prima facie in nature of force majeure and passed interim order restraining invocation of bank guarantees, while holding that where special equity exists, the court is empowered in facts and circumstances to injunct invocation or encashment of bank guarantee. So we are till date seeing a very positive response which is happening. I have another set of 3 cases where in one case of India Bulls versus SIDBI, Delhi High Court, the court on a petition challenging the demand of loan repayment by SIDBI restrained SIDBI till petitioners seek clarification from Reserve Bank of India whether circular dated 27 March 2020 on moratorium of loan repayment extends to NBFCs also. Government also, in the case of Anil Agarwal, Delhi High Court, dismissed a petition saying that they were not inclined to get into executive policy and would not order a shutdown of the public sector undertaking in the case which was filed. A recent case of aligned component of Bombay High Court, the court held that where lockdown restrictions have opened and if the employees do not report to the work, the employer has the right to deduct the wages of those particular employees. But we saw a recent case some 4-5 days back where the bench of the Bombay High Court itself has also given one judgment which is subject to a caveat saying that subject to further orders and subject to the final outcome, that no work, no pay will not be applicable during the period of this crisis. So, overall, we are seeing the directions of the court. Overall, we see that there would be an increase in the litigations which is expected. And when companies do take decisions to go into litigation, they would obviously put cost also as one of the priorities in their decision making and various judgments at the back of the mind to decide a forum. But in all cases, as a corporate, I feel that we would first appreciate going into negotiation and mediation, then land up into an expensive arbitration or litigation before the courts of law. This is my last slide on transactional practices. Whenever there is a crisis which has happened, like for example, financial crisis of 2007 to 2010, normally transactional contracts see a little downturn, but litigations, the practices tend to be steady, which means the cases would completely go on a random basis to a level which was there previously and may to an extent rise also in the situation if force majeure is not interpreted in a particular manner by each companies while performing their contract. So this is from my side. Thank you very much.
Thank you for that, Zameer. Hi, everybody. My name is Anita, and I'm one of Richard's colleagues in London. So thank you for joining us on a Friday afternoon. So you've heard from Richard and Zameer regarding how the dispute resolution system is coping with the current COVID pandemic and what types of disputes we are seeing and how the courts are interpreting the force majeure clauses in this current time of crisis. What I'm hoping to speak to you about this afternoon is the legacy I believe that the COVID-19 will leave behind to dispute resolution going forward. So in other words, what short-term emergency changes we have seen that have been implemented during this time of crisis, which I think will survive longer term as we head out of this pandemic, but also what changes we should anticipate to the way in which parties will approach dispute resolution more broadly going forward, how parties' attitudes to dispute resolution is likely to shift as a result of this pandemic. So turning firstly to the changes which have been adopted in the short term and which I believe will survive in the longer term. Obviously, we've seen a huge reliance on technology and an increased use of technology as a result of this crisis. And the courts and the arbitration centres around the world have largely shown themselves to be very successful at running hearings remotely, and they've made these changes very quickly and adapted very quickly in response to the crisis. And I think parties will ask themselves after this, why can't we continue to do this in the new world? You know, if arbitrations can be run quite successfully or almost as effectively as they do in person, why do parties need to pay to fly arbitrators and potential witnesses halfway across the world, or pay for expensive hearing rooms at arbitral centres, or pay for hotels for arbitrators or for witnesses? So I think we will see parties wanting for virtual hearings to continue. What I do think we will see is that for lengthier or higher value cases, that those types of cases will return to the court system rather than continue by way of virtual hearings. And I say that because, as we spoke about previously, and I am someone who believes that you just cannot quite replicate the feel of the adversarial process of a court proceeding and the drama and excitement of a barrister often intimidating a witness or waving their arms in the air and that kind of thing. You can't replicate that virtually. And for more high value cases, it might actually be part of the case strategy to have that adversarial process in place and have that tension in the room from which they can take advantage. And the cost of going to court will be less material in a high value case as it might be for a smaller case. So those kinds of cases, I believe, will go back, and arbitrations as well, will go back to face to face. On the other hand, I think for smaller cases, smaller value cases, or interim procedural hearings on larger cases, they may be able to continue to occur remotely because often they have less witnesses that need to be cross-examined. It matters that they cost a lot to go to court, and they probably are also less document heavy. So we might see a change for smaller trials or for interim procedural hearings to continue to take place remotely. And I think if that happens, the other thing that we will see, and that's something that we've already seen to date, is that the uninterrupted length of sitting time will have to decrease. So, for example, as you know, we can't concentrate as well electronically as we can sitting in a room. You know, that's why I'm going last in this, because you've concentrated the best for Richard and second for Zameer, and I'm last when maybe your concentration is waned. No, I'm just joking. But I think parties will have to build in more breaks, or they will have to spread the hearing out over a few more days in order to adopt for the fact that people can't concentrate as well electronically. And that might be a benefit to you, or it might be a disadvantage depending on, for example, if by having a break, it gives the other side additional time to prepare to cross-examine your witness, for example. So those are some of the changes, you know, I have seen to date that have been implemented in response to this emergency, which I believe may survive this crisis. And the second thing I would like to talk to you about today is how the dispute resolution landscape may change more broadly as a result of the COVID-19 pandemic. And in particular, the fact that parties are likely going to approach dispute resolution with a different attitude in the new world, and that they will want disputes to be resolved more holistically. So as companies continue to suffer from the economic and financial strain as we head out of this pandemic, their primary focus is going to be on how to continue to themselves survive, and they will be less willing to be distracted by the time and cost commitment and the financial risk of lengthy court or arbitral proceedings, and Zameer has definitely referred to this as well. And with court proceedings, the dispute resolution process is often not in the parties' hands to control. So parties in the new world, I believe, will be more willing to work collaboratively in order to achieve a mutually beneficial outcome, or at least a mutually acceptable outcome, rather than always the adversarial approach of commercial litigation. And as we know, the dispute resolution process, which lends itself to achieving such a holistic result, is of course mediation. You know, parties can be more creative in the solutions they come up with, and often in a way that is not achievable in commercial litigation or in arbitration. So, for example, if we think of a supply chain type dispute, and you are in a dispute with your supplier and you rely on the supplies you receive from your supplier to on supply to customers, perhaps in the old world, if you sued that supplier, you would have gone at them for every last pound you can. Whereas in the new world, it might be in your best interest to come up with a solution such as investing in your supplier or buying out your supplier, because you don't want your supplier to collapse. If you sue them and they collapse, then that's not in your best interest. And so I think parties will have to be more creative in how they resolve disputes in the new world. So Richard mentioned before that because mediation does benefit from being in person, we have seen a decline in mediations during this pandemic. But actually what we think is going to happen after, or as we come out of this pandemic, is that actually the number of mediations will increase because of the benefit of this flexibility of the mediation process. Arbitration also has a number of benefits to normal commercial litigation, which will make it a preferred dispute resolution mechanism post-COVID-19. So firstly, I believe it's very likely that there will be a huge backlog of cases going to be heard in the courts around the world, despite the fact that the courts have actually made a huge effort to try and adapt and to continue with business as usual during this crisis. So I think this is going to result in really lengthy delays for parties to have their matters go to trial, when actually post a pandemic, all the parties really want short, sharp, cost-effective solutions to their disputes. I'm not quite sure what the position is in India, but definitely in London, even before the pandemic, if you wanted a matter listed for trial, say a 2 or 3 week trial, you're already, if you listed that today, the first available date you will get would be 12 to 18 months from now. And I think when this pandemic is over, or as we come out of this pandemic, that delay might be 24 months. And parties are not going to want to wait for 2 years to resolve their dispute when there's pressure economically. There's also an awareness, I think, in arbitration already that of the cost of taking certain steps in arbitration. So, for example, parties know that they need to pay for the arbitral tribunal, and perhaps parties are going to be willing to work more collaboratively in attempting to reduce the cost of the arbitration. So, for example, they could agree for the arbitration to proceed by way of a sole arbitrator rather than to appoint an entire arbitral tribunal, and they might agree for it to be a documents-only arbitration, so that the dispute is determined on the documents alone, and that a hearing doesn't take place. And secondly, as we all know, one of the major advantages of arbitration and mediation has always been the fact that it's confidential, and I think this is going to become even more important in the post-COVID world. And parties are going to be more reluctant to have details of the disputes shared to the public, as is the case in court proceedings where they are open to the public. And I say this because having that information in the public, I believe that companies might feel that their competitors could use this information in a way that could harm them when they are already in a vulnerable position in this pandemic. And so they might want to make sure that resolving any disputes they have with another party is done confidentially, so that their competitors do not get the advantage of knowing this information. And lastly, I think that the pandemic has resulted in parties having been forced to look more closely at their contract terms. So as Zameer and Richard spoke about before, I think previously a force majeure clause was something that no one really looked at, and now everyone is obsessed with what it says in their force majeure clause. And I think going forward, and as parties enter into new contracts, everyone will want to make sure that their force majeure clause includes the possibility of a pandemic or an epidemic, if they want to rely or get the benefit of that in the future. And equally, I think the same is true for the dispute resolution clauses. If parties want to have disputes resolved quickly, and knowing that there's likely going to be delays in the court system, they will want to include in their contracts dispute resolution clauses that provide for mediation or mandatory mediation before the parties can go to court, or to include an arbitration clause so that the matter is determined by way of arbitration and done quicker. And so those are my preliminary thoughts as to what we have seen, the massive changes we've seen to date, and what I think we will see as things come out of this. But as we know, it's a crystal ball, and these changes have happened so quickly, both in our lives and to the dispute resolution system. It is a little bit, remains to be seen, but I'm interested to see how things go from here. So thank you everyone for joining us.
Okay, so thank you, Anita and Anita, such an informative session. Richard, I have a question to you. How does virtual mediation take place in UK?
How does virtual mediation take place in UK?
So thanks, Nidhish. So I touched on this briefly in my presentation. The virtual mediation is quite similar to what we're doing here. I'm getting an echo here. Anita, are you on mute? Thank you. Yeah, that's better. Thank you. it's quite similar to what we're doing here, really, which is what we sit in front of a screen, and you have a plenary room in one set of online photos, and then breakout rooms in other types of photos. And the mediator moves virtually, drops in to those various rooms virtually. So the mediator tries to conduct the mediation in the same way online as he does in a physical environment. Now, the challenge around that is, as we know, for those of us who have been involved in mediation, is that firstly I touched upon the physical, the face-to-face side of things, but also I think the other challenge is the one that Anita referred to, which is the concentration span of sitting in front of a screen. Mediations go on for hours. People sit in mediations for 15, 18 hours overnight. That's really, really difficult to adhere to on an online basis, staring at a screen for that length of time. Likewise, the parties are in their caucus rooms for a period of time, and again, that's quite difficult to do online. So the virtual mediation is in many ways quite similar to what we see here, and there are systems and there are online systems that are available which effectively are online mediation systems. But I think what they miss out on is that personal interaction. Also, the technology challenges I think are significantly greater with the mediation than they are for a court hearing or an arbitration, where effectively you say, okay, we're going to sit for 2 hours, we'll then have a break, we'll sit for 2-3 more hours. So the maximum time in front of your screen is for relatively short chunks of time, where in fact it's also broken up, and that's just not the way the mediation tends to work. So it can work, but I think one can't simply do as one has done with the court process, where you move it over to an online system and do it in the same way. I think for an online virtual mediation to work, I think we've got to be really quite creative about it, and I think that's what we're still struggling with, as to how best we make that work.
Thanks, Jud. Thank you. So I have one common question to both you and Zameer. See, what's happening in India is that, and I'm sure same thing must be happening in UK and across the world. There are organizations, whether it's a smaller organization, MSME, or a small and medium enterprises, or a large foreign multinational. All these organizations take commercial leases. Lot of people have taken apartments on rent. What's your viewpoint with respect to both commercial lease and residential apartments? Do you think that organizations, corporates would like to mediate this, or would like to go in for the court? What's your first-hand view on this? That's first. Second is that across the world there are salary cuts, there are layoffs which are happening by so many organizations. What do you think? Will this also be mediated between the organizations and the workers, or will this go all? So Zameer, from you as an in-house perspective, what would you choose? Would you choose to mediate this and close this chapter, or would you want this to go to the court and let the court decide?
Yeah, so my perspective is that I am a big believer of the 2017 judgment and the other 3 judgments which are there in the history of India. That force majeure is subject of a strict interpretation, because it can't be then used as an excuse to get out of the contract. Number 1. Number 2, during this time where courts are taking some humanitarian grounds also to give a relief, it will really be tested. It will be litmus test between humanity and the letters of the contract. So do we honor the contract in terms of letter and spirit both, or it's only the letter and then there can be an intervention by act of God? Number 2, I would always go for the route of mediation, because there are debatable questions on the performance of the contract. If it is very clear-cut contract, I'm on for it. But 80% of the time, I would feel that people would go into a route which is of negotiation and mediation. It's not about terminating the relationship right now. It's only the temporary suspension and continuation of the long-term relationship, which is the focus. So that's my view on it. Thank you.
And what about the workers who are working, and about layoffs and their salary cuts? What do you think from that perspective? Zameer?
My view on the workers?
Yeah, workers. I mean, especially on the cutoffs. I mean, layoffs and salary cuts.
My view is that the government and the courts are really interpreting and intervening. So matter is sub judice at this point of time. I'm only of the view at this point of time, when I am advising my government, my corporate or the company, is that whether we go by the letter of the law or have some spirit in that of humanity touch to it. If I have a strict interpretation of the contract, if you see the 2017 judgment, there was a change of law which happened from the Indonesia side, which completely changed the price of the coal. And that's what the difficulty Tata and Adani was having to perform the contract. Now, if I go by the strict interpretation of the law, I think force majeure is subject of a strict interpretation. There can't be a liberal interpretation to come out of the contract. If the performance is completely challenged on the ground that it's become impossible, and the provision has been made, or the provision has been made under the contract for that particular area, then force majeure will apply. Like for example, in the 2017 judgments, Tata and Adani had a choice to choose between a tender which is escalable and non-escalable. All right. They choose non-escalable, which means now you can't change the price by using hindrance as an option, So those are all facts which have gone into it. I think everything has to be looked in the letter of law. If you ask me for a force majeure, it has to be a strict interpretation is what I believe, and that's what the courts have interpreted. And if it is not interpreted in that manner, then the liberal interpretation will really put all contracts to be used and hit from the shoulder of force majeure, is my part. So that's what I feel in terms of termination of your contract, in terms of your performance of goods and services, in terms of your employment and other contracts. That's my view.
Thank you, Zameer. Richard, would you like to give your viewpoint on this?
Sure. I just jotted down a couple of points again from a UK perspective. It's interesting that one of the areas that the English court has specifically indicated it's going to help individuals with is in relation to mortgage possession proceedings. Mortgage possession proceedings, in other words, where you fall into default on your mortgage payments. The court has indicated that those are suspended until September. So the court has effectively said that there's a moratorium on that type of enforcement already, which gives a very clear steer to landlords in a residential context as to what they should be doing. They should not be going to court, and therefore there's a clear steer from the government and the courts that we should be holding off taking active court steps in relation to individuals in that situation. That's very consistent with the general societal mood at the moment. In terms of broader concerns about lease terminations and defaults on rent, I think another relevant factor, we haven't really touched on this yet, is reputation. Organisations at the moment are going to be very keen to protect their reputations and not to be seen as the bad guys taking advantage of this global disaster. For an organisation to start
Nidhish,
taking
I have a
steps,
promoter call. Can I proceed? Thank you.
For an organisation to be taking steps to enforce, to terminate leases, etc., would look very bad reputationally. And so I think that will be a significant driver in relation to all this, and an encouragement for organisations not to take aggressive court steps. But again, it's going to depend on a whole number of other circumstances. Some of these are going to be very high value disputes where actually you've probably got no choice but to go to court. But that should, I think, and will in fact be the exception rather than the rule, I think.
Okay, thank you, Richard. Thank you so much. Unfortunately, Zameer had to leave for a promoter call, which he mentioned to me last evening. So I think the session was very good. We learned a lot of new things from the UK perspective, and also a lot of things from Zameer and Anita both. So thank you so much, Richard and Anita, for accepting our invitation, and it was very kind of both of you to come spare your precious time and give your inputs on such a very delicate and a very, very important issue in today's time.
Thank you very much. It's been our absolute pleasure to get involved. So thank you for inviting us, Nidhish. Thank you everyone for listening.
Thank you.
Thanks very much, Nidhish. Thank you.
Thank you, participants.